David and the judge and I have had the pleasure of presenting this talk to the New South Wales Bar Association, but our audience is a little bit different today. And I just wanted to share some stories with you, both when I had the pleasure of working for Justice Clark and Michael Kirby back in 1994 and 1995. And in that time, obviously, I saw a lot of appeals. I had 2 years of exposure of appeals in the Court of Appeal. And I can say that times have changed a lot from 20 years ago. Is that 20? Or even more, 30 years ago. Because back then, we didn't really have litigants in person. We had a couple. We had Kate Wentworth, who appeared, and we also had Dr. Rajki, only 2 or 3, and that was it. So it was very different to now. And when we did our talk before the Bar Association, we did spend quite a bit of time talking about appearing before the court when you're dealing with a litigant in person. And it's very different to when your opponent is a litigant in person to when you are appearing against a senior counsel or junior counsel on the other side. Because the one thing about advocacy, I think, is the ability to be agile. And I have said to actually Robert McDougall that, when you're appearing before Silk, they're so sneaky. Like you think you've got them in a corner and then they slip out from under you and then they trick you. And then Bob said to me, well, Laina, you call that being tricky, but I just call that being agile. So it's really annoying. I find it really annoying when they're tricking me and slipping out from under me, but the only way that you can really be agile is if you're prepared, because only with preparation, where I know everyone keeps saying preparation, preparation, preparation. That's what you heard this morning as well, when we had Justices Smith and Judge Carty speak, and they emphasized the importance of preparation. And the President has emphasized that. And I remember when I was working for Justice Clark, we had a lot of Silk appear, and they wouldn't even appear to have read the brief. And once he was so upset with the Silk who was appearing before him that he actually sent him away to prepare and then to come back in the afternoon. And so I don't think from the point of view of a senior junior that there's any particular trick about appearing in, well, there is, any particular, is it trick, or the most important element of it is preparation, because you can be the most amazing, you could be the most amazing senior counsel, but if you haven't prepared for the case and you don't know your brief, then you're really not helping yourself or you're not helping the court. And then you'll end up in the situation that Justice Smith said, that you feel that you just wish, what did he say? That an earthquake would happen and swallow you up, because that has happened. That obviously, I'm sure in all of us as practitioners has happened to us in the past, where you think that you show up to court. This happened when I was a solicitor. You show up to court and you think that the case is going to be run in a particular way, and you can't work out, because when I was a solicitor, I did lots of defense work, or mainly only defense work, and you would come to court and you'd think, there's no way the plaintiff can win this case. I just don't see how the plaintiff can win this case, and the winning case is for the defendant. And then the plaintiff starts speaking and you go, oh my God, I hadn't thought of that, right? And we had no idea that was their case. And I'm sure, if all of us are honest, we've been in that position before, where we probably haven't thought about it enough. We haven't put ourselves in the shoes of our opponent to try and work out all the possible arguments that they might have. And when we're talking about preparation in the court, the most important thing is to try and preempt the questions that the bench might have for you. And I know that even with the best of intentions, even when we have done all the preparation, we've thought that we have preempted all the questions. Obviously, sometimes questions are thrown at us that we just, even with the best of intentions and best of preparation, we haven't thought of. But then there are also other instances where your instinct is right, and you know that this is a particular weakness in your case, and the bench will for sure ask, that could be the first question that's asked of you. So it's really important to be prepared, and sometimes you can be fully prepared but still appear unprepared. I don't know if the bench can pick that up, because you think you've done all the preparation that you need to do, you preempted all the possible questions, but then a question still comes at you out of left field. Or you're faced with a sneaky senior counsel who tries to trick you. Right, Pritchard? You wouldn't do that. That's all right. So I just wanted to tell you the difference for me between appearing against a litigant in person and a senior counsel. Last time we had this talk, the judge gave me a tip, or gave everyone in the audience a tip, that we had to really prepare our written submissions fully and hopefully so that the full answer of your case or defense, because litigants in person are generally the appellant, is in the papers. And so that unless the court asks you to elaborate upon what's in your written submissions, and you should be content to rest upon your written submissions, because otherwise it would open up the opportunity for the appellant to address the court at length in reply to your submissions. That can work in some instances, and Michelle and I were actually in the Court of Appeal a few weeks ago, where we were the amicus curiae for the Court of Appeal. They were seeking to declare a litigant vexatious, and we had prepared all of our submissions, written submissions, and I was a bit worried. One of the tests for whether or not a litigant should be declared vexatious was whether or not they had commenced proceedings, vexatious proceedings frequently in the court. And in this particular fact scenario, this gentleman, Mr. Proetti, had resisted, is it Section 88K, orders for sale of the property, a partition or sale of his property, because the property had been left to him and his brother, and his brother couldn't get him to agree to a sale, but eventually his brother brought proceedings in the New South Wales Supreme Court to force a sale of the property. He was unsuccessful in resisting that, and he appealed all the way to the High Court. But even after his appeal to the High Court was unsuccessful, he continued to commence proceedings to try and have the decision overturned, amongst other things. But he'd done this for 5 times after the special leave to appeal was refused. And I was concerned that 5 times over a period of 6 months may not satisfy the definition of frequently. And we had put the relevant case authorities in our submissions, but after Mr. Proetti had addressed the bench, I think over 90 minutes or 2 hours, very repetitively, I got up and I asked, it was my turn, and I asked the bench if they would be assisted with any more authorities on the issue of frequently. And I had provided the court with a list of authorities, and I had asterisked the additional 4 cases that might be of assistance, but I didn't want to force it upon them if the bench didn't feel that they needed the assistance. And I asked the bench if they did, and actually Justice Dern said that for her part, and this is a plug for myself, and for her part, that she said that she found our submissions very clear and the principles were very clear and she didn't need any more assistance. And so I only spoke for about 10 minutes in total to address the one key issue that I thought needed to be addressed. And because Mr. Proetti clearly believed subjectively that he was in the right. And there was a High Court case that made it very clear that the subjective beliefs of a litigant in person are irrelevant. It's whether objectively the proceedings that they were bringing are vexatious. But that's a very different approach to the approach you would take if you have a barrister or a barrister on the other side. In that case, I think you have to be really on guard. You're on guard, and you can really only do that when you are fully prepared. So I think we should take some questions. We've been running so to time today that we haven't really had a chance to, apart from the interactive ethics session, to take questions from any of you. So I think we should open up the floor to questions.